Welcome to Week 4's recorded lecture on character evidence. We will cover pages 137 to 156 from your casebook. First case that we'll cover is Tucker v. State. This is a Supreme Court of Nevada case from 1966. In this case, a defendant was acquitted of a homicide with very similar circumstances to the homicide at issue in this case. The defendant was intoxicated and woke up to find someone had been killed in his home. This was the same circumstance at the case at issue. Both times, the defendant claimed not to know what had happened to the deceased. At the second trial, the defendant was convicted of second-degree murder, and the plaintiff introduced evidence of that first homicide. The issue is whether the trial court erred in admitting evidence of the prior incident. The holding in this case, the court reversed, finding that the evidence of the prior homicide should not have been admitted. The court here felt that the evidence did not amount to establishing a non-propensity purpose, that being, again, identity, motive, intent, common plan, etc., because the defendant had not been convicted of the prior homicide. Even though he might have, and we know based on the unique set of facts that he probably did commit the prior murder, because the jury in that case did not find that there was clear and convincing evidence of guilt, he had been acquitted. This court felt that because there was not clear and convincing evidence of his guilt in the prior crime, it could not be introduced as evidence now of even a non-propensity purpose like common plan. This is a very rigorous standard and more rigorous than the court that had applied in Arredondo that we've covered previously, and it is also more rigorous than the standard that we'll see in the next case in Huddleston. In Huddleston v. United States, this is a Supreme Court case from 1988. A defendant was accused of selling stolen goods in interstate commerce. The defendant had sold 5,000 blank videotapes at below cost. The defendant didn't deny selling the tapes, but he did deny knowing that they were stolen. The government offered evidence that the defendant had previously sold large quantities of stolen goods for a low price, and they offered this to show a guilty knowledge. At issue here was whether the trial court should have introduced evidence of these prior similar acts. The defense argued that the government needed to first make a preliminary showing by a preponderance of the evidence standard that the defendant had actually committed those prior similar acts that he was not charged for. The trial judge held that all that was required was a showing of evidence sufficient to allow a reasonable jury to conclude that the defendant had committed the prior acts. The court made this decision based on conditional relevancy. The court will admit conditionally relevant evidence if there is evidence sufficient to support a finding that the condition has been fulfilled. So what this means is the court felt that the evidence should come in conditionally if evidence would later come in to then prove this first initial piece of evidence. The holding in this case, the court affirmed the government does not need to make a showing by a preponderance of the evidence that the defendant had committed that prior bad act, in this case, selling large quantities of goods at low cost. This court felt that the FRE did not call for the standard of proof that the defendant was asking for, and that the defendant is still protected by a judge weighing that prejudicial versus probative value of the evidence, which they do with every piece of evidence admitted. So comparing Tucker and Huddleston, would Tucker v. State, the prior case, have been decided the same way in a jurisdiction that followed this case's ruling with Huddleston? Answer being probably not. In this case, the trial judge doesn't weigh the credibility or make a finding that the government had proven the uncharged misconduct by a preponderance of the evidence. And then the proof required in Tucker was clear and convincing, an even higher standard. The next case we covered is Perrin v. Anderson. This is a United States Court of Appeals for the 10th Circuit case from 1986. Perrin, the deceased, was shot and killed by highway patrol officers. His survivors brought a civil action, claiming damages for deprivation of civil rights. The officers and the deceased had gotten into a fight when they followed the deceased home to get information about a traffic accident. The officers claimed the deceased attacked them. One officer testified that he was afraid of losing consciousness because the deceased was kicking him in the face and chest. He then shot and killed the deceased without any warning. A trial judge allowed the officers to testify that the deceased had attacked them on previous occasions. The issue is whether the trial judge should have allowed the officers to testify about these previous attacks. And one thing to note and remember is that this was a civil case, not a criminal case. The trial court held that even though it was a civil case, the character evidence is admissible in certain civil cases when the central issue involved is criminal in nature. This is contrary to what the FRE suggests, that this is supposed to be for criminal cases, and also contrary to what other courts had decided at the time. Since this case, the FRE has been clarified that FRE 404 is limited to only criminal cases. The holding in this case, the court held that the evidence of the deceased's prior bad acts were not properly admitted under FRE 404 because they came in the form of specific incidents versus reputation evidence or opinion evidence. And because the deceased's violent character was an issue, the character evidence could only have been admitted in the form of reputation or opinion. However, the court also held that the evidence of his prior bad acts were admissible as evidence of habit. And next case we cover is Rosebrook v. Eastern Shore Emergency Physicians. In this case, a patient had fallen and suffered injuries. Her ER physician indicated in her notes that the patient had experienced knee and hip pain, but no back pain. The patient had been brought into the ER on a stretcher. It later turned out that the patient had fractured a vertebra, which, untreated, became infected and then led to her death. Her physician testified at trial that she didn't remember the patient, but that every time she treats a patient on a stretcher, she examines their back. The issue in this case was simple, whether the physician's testimony should have been admitted, and the court held that yes, this was testimony of habit and that it was admitted properly. The next case is Olden v. Kentucky. This is a Supreme Court case from 1988. As background, this was a sexual assault case involving the defense of consent. There are a lot of facts in this case, and it is a very fact-specific holding. After the incident at issue, the defendant drove the victim to the house of his half-brother, Russell. The defense wanted to cross-examine the victim about an alleged affair she was having with Russell, and the trial judge excluded this because of rape shield laws. The issue was it constitutional error to exclude the evidence about the victim's relationship with Russell? The Supreme Court here held that yes, this was constitutional error. The defense was unable to conduct a full cross-examination of the victim in violation of the Confrontation Clause. So does this mean that rape victims can always be cross-examined about their current sexual partners on the grounds that they might be lying about the assault so that their current partner won't be jealous? And the answer is no. This is a very, again, fact-specific case, and the Supreme Court held that, in this case, because the alleged boyfriend, Russell, saw the victim get out of the car with the defendant, the victim's motive to lie was greater. And it was greater than if she had reported the assault before she saw Russell while she was with the defendant. The facts in this case are specific, and the Supreme Court held that this does not mean that the defendant's right to confront a witness has been denied anytime a court doesn't allow the free cross-examination of a victim about their current sexual partners. However, this is an example about how evidence of prior sexual conduct can still be admitted, even with strong rape shield laws. And that concludes the cases that we covered in this week's reading. Next week, we will continue character evidence and we will summarize the rules that we discussed last week and this week, and then practice comparing and contrasting the FRE and the California rules.